Okay, let's unpack this with a truly provocative question about power, retention, and accountability at the state level. Imagine the highest law officer in any state. They're mandated by the Constitution. They advise the chief minister and the entire cabinet. They can walk onto the floor of the state assembly and debate policy. And yet their job can be terminated tomorrow by the executive they advise, with no reason given. They have zero security of tenure.
That is the perfect encapsulation of a constitutional paradox. And we are talking, of course, about the Advocate General of the state. It's an office that is, absolutely fundamental to the rule of law and state administration, yet it is designed to operate with an inherent political vulnerability. It sits precisely at that tension point between legal excellence and political reality.
Absolutely. Welcome back to the Deep Dive. Our mission today is laser-focused. We are undertaking a critical, deep analysis into the constitutional architecture of the state's chief law officer, the Advocate General. And we're basing this on the framework laid out in Laxmikanth's definitive text. For anyone diving into the complexities of the state executive, especially if you're prepping for civil services exams, understanding the fine print and the political implications of constitutional bodies like the AG is not just important, it is essential for strategic preparation. Now, before we jump into Article 165, just a quick, heartfelt note to you, the learner. If this in-depth content, the type of material that connects the dots across your syllabus, is proving useful for your preparation, please humbly consider subscribing to our YouTube channel, Simplified UPSC by PPP. And if you are capable, joining our paid membership community. That support is absolutely crucial for sustaining the creation of this kind of detailed, high-utility material for everyone.
We deeply appreciate every single listener, and a massive thank you, a really warm shout out to all existing members whose commitment is just invaluable to keeping the gears turning here. Your support truly helps us focus on delivering quality.
And as always, please do like this audio or video and share your valuable comments. Your engagement helps us reach more learners who need this targeted insight. Remember, we have structured resources available to help you master this material. We have free notes and practice previous year questions, PYQs, available right now on our Telegram channel. If you're one of our Legend YouTube members, you get exclusive access to premium notes, extra PYQs, and model mains answers on our dedicated Discord channel. Don't miss out on those crucial study materials. They're designed to translate knowledge into examination success.
And our mission today is more than just outlining Chapter 54. It's about providing the strategic context. We will link the pivotal role of the Advocate General directly to the surrounding state executive structure, analyze the critical constitutional doctrines that govern the state's legality, and connect all of it to core UPSC mains analytical themes. We want to get to the why behind the what of these constitutional provisions.
Okay, let's establish the foundation. The Advocate General, the AG, isn't just a high-ranking bureaucrat. This is an office woven into the very fabric of the Constitution. Where exactly does the AG reside within that structure?
Right, so the Office of the Advocate General of the State is fundamentally anchored in Article 165 of the Constitution.
Yep.
This places the AG firmly under Part 6 of the Constitution, which specifically governs the state governments. That whole part runs from Articles 152 to 237. And because the office is explicitly mentioned and established by a constitutional article, it is officially classified as a constitutional body. This formal status is really key to understanding its authority and reach.
Okay, so Article 165 creates the post. But who fills it? And under what qualifications? Is the standard, similar to the judiciary?
The AG is appointed by the governor.
Oh.
And regarding qualifications, the Constitution specifies that the person appointed must be qualified to be appointed a judge of a high court. This is a high bar. Generally, it means they must have held a judicial office for 10 years or been an advocate of a high court for 10 years. It's to ensure the highest level of legal competence is available to advise the state government.
And what does the AG actually do? What are the core functional duties that define them as the state's highest law officer?
Functionally, the AG serves three primary roles. First and foremost, they are the chief legal advisor to the state government. They provide counsel on really complex legal matters and perform legal duties that are assigned to them by the governor. Second, they discharge the functions conferred upon them by the Constitution or any other law. This includes, representing the state in various legal proceedings. Third, and this is where it gets controversial, their role carries a degree of political loyalty, advising the executive on the legal implications of its policy decisions.
That immediately brings up the comparison with their counterpart at the Attorney General of India, the AGI. That's a crucial point of comparative polity for the Civil Services exam.
Absolutely. The AG at the state level under Article 165 and the Attorney General of India at the union level under Article 76 perform perfectly analogous roles. They are the chief legal advisors for their respective governments. If we look at the AGI's duties, which are assigned by the president, they include appearing on behalf of the government of India in all cases in the Supreme Court where the GOI is concerned. They also appear in any high court in any case in which the government of India is a party, and they provide advice on complex legal matters referred to them by the president. The Advocate General performs the precise equivalent for the state, defending state laws and advising the state executive within its own judicial and legislative jurisdiction.
What's fascinating here is that both of these offices exist because the executive needs high-level, constant legal vetting, not just in court, but during policy formulation itself.
Precisely. They are the essential constitutional link between the executive's political will and the constitutional rulebook. They're meant to be the voice of legal sanity inside the cabinet room.
And speaking of access, let's turn to where the AG becomes truly unique and incredibly powerful. This power and privilege nexus established by Article 194. This is where their advisory role spills over directly into the legislative domain.
Yes, Article 194 details the expansive powers, privileges, and immunities of the Advocate General. This article grants the AG a truly remarkable, almost contradictory dual status. The AG has the right to speak in and otherwise participate in proceedings of both houses of the state legislature or any committee thereof of which they may be named a member.
Okay, let's pause on that.
Yeah.
This means the chief lawyer of the executive branch is literally sitting in the legislative branch, debating proposed laws before they're even passed. That's a level of access almost no other unelected official possesses.
It is completely unparalleled. Think about the strategic importance of that. The AG is there to preemptively ensure that a bill, as it is being debated and amended, doesn't contain any legal or constitutional flaws that could lead to it being struck down later by the High Court or the Supreme Court. They are essentially the state's internal constitutional review mechanism for the legislature. They are ensuring legal hygiene during the lawmaking process.
So they are informing policy, participating in legislative discussion, essentially shaping the legal landscape of the state. What is the constitutional check on this immense access?
The constitutional check is vital. The Advocate General does not have the right to vote in the legislature. They can inform, advise, and guide the lawmaking process, ensuring the government's actions are legally sound, but they cannot determine the outcome of a vote. They can't cast the decisive ballot. This delicate balance of participation without voting power is crucial for preserving the separation of powers and maintaining the rule of law. They are advisors, not legislators.
This brings us to the most analytically crucial point for the Civil Services Examination: the appointment structure and the resulting insecurity of tenure. The AG is appointed by the governor, and the Constitution is extremely clear on the term of office.
This is the defining vulnerability and the classic tension of the office. The Advocate General holds office during the pleasure of the governor. The Constitution does not fix a specific term of office, nor does it lay down the procedure or grounds for their removal.
And if the governor's pleasure is the mechanism, how does that translate into the political reality on the ground? What does that really mean?
In political reality, the governor acts on the aid and advice of the Council of Ministers, the cabinet. Therefore, the AG serves at the pleasure of the ruling state government. This means two fundamental things. First, when the government resigns, when the Council of Ministers changes following a no-confidence motion or a general election, the AG is generally expected to resign. The new government must have a legal advisor in whom it has complete faith.
Someone who is aligned with its policy agenda.
Exactly. So the role is highly politicized, despite demanding absolute legal impartiality. That has to create immense pressure.
It absolutely must. And that leads to the second, more insidious implication, right? The lack of security of tenure raises serious analytical questions about the independence of the legal advice being provided.
It's a huge question. Suppose the ruling government proposes an ordinance or a bill that, in the AG's professional opinion, is legally shaky or potentially violates a fundamental right. If the AG provides advice that contradicts the executive's short-term political interest, they risk being dismissed instantly. There's no appeal, no inquiry, and no need for the government to provide any grounds for dismissal.
So that suggests the Advocate General might be incentivized to provide advice that is politically convenient rather than what is constitutionally robust.
That is the structural flaw. The role demands complete legal objectivity, yet the condition of service ties the official directly to the political fate and immediate policy needs of the executive. For the UPSC mains exam, this tension accountability versus independence is a classic point of analysis. When constitutional posts lack tenure security, their ability to act as independent constitutional watchdogs is significantly compromised.
Let's put this in stark terms. A high court judge, who the AG might argue cases before, enjoys deep security of tenure and can only be removed by a complex parliamentary process. The AG, their legal equal in qualifications, can be fired by a simple stroke of the governor's pen acting on ministerial advice.
Exactly, and that highlights the distinct nature of the AG's role compared to the judiciary. The AG is part of the political executive. They are its chief counsel. And if you contrast this with the Attorney General of India, that role also suffers from the same lack of tenure security. It confirms this is a deliberate design choice across both the union and state levels. The goal is to ensure the ruling dispensation always has a legal representative aligned with its vision. They are the government's legal face, not an independent constitutional authority like the Election Commission or the Supreme Court.
That deeper understanding of the constitutional design choice is key. It's not an accident. It's a feature of our parliamentary system that ties the legal office to the executive's lifespan. To truly appreciate the AG's function, we have to step back and place them within the immense state executive apparatus, the environment they are constantly advising. This requires understanding the power dynamics between the governor and the chief minister. Let's start with the governor, the formal head of the state.
Right. The governor, covered under Articles 153 to 162, is the nominal executive authority, or the de jure executive, of the state. They are the formal face of the state government. Under Article 166, all executive action of the government of a state has to be expressed to be taken in the name of the governor. So the AG's advice is directed toward the government, which constitutionally acts in the governor's name.
And the governor is appointed by the president, which really means the central government, as detailed in Article 155. This is the first and most fundamental introduction of a strong, centralizing, quasi-federal element into the state political system, isn't it?
It is the defining centralizing feature. The governor is, in essence, the agent or nominee of the center. This appointment structure ensures that the union government has oversight and a direct representative within the state administration. It's an indispensable element of our quasi-federal framework.
Beyond just the executive formality, the governor possesses significant and often controversial judicial powers under Article 161. What are the key distinctions here compared to the president's pardon power?
Okay, so Article 161 grants the governor the power to grant pardons, suspend, remit, or commute sentences in certain cases, specifically for offenses against any law relating to a matter to which the executive power of the state extends. The crucial limitation, which is a point of frequent comparison in exams, is that the governor cannot pardon a death sentence.
And why that difference? Why does the president have the exclusive power to pardon a death sentence?
Well, the constitutional framers intended to preserve the ultimate judicial authority for the most extreme sentence, the death penalty at the union level. It was to ensure consistency and centralize that final decision away from potential state-level political pressures. However, the governor does hold concurrent power with the president to suspend, remit, or commute a death sentence, meaning they can reduce the severity or duration of the punishment, but they cannot grant an absolute pardon. That distinction, concurrent power for suspension and remission but no power to pardon, is a crucial point of comparative polity.
Now, let's address the most politically sensitive area of the governor's authority, discretionary power under Article 163. The AG advises the government, but the governor is not always bound by that advice.
That is correct. Article 163 mandates that the governor acts on the aid and advice of the Council of Ministers, except insofar as the Constitution requires him to exercise his functions or any of them in his discretion. The Constitution recognizes specific situations where the governor has to act independently.
What are some examples of these special responsibilities where the governor acts without or even contrary to ministerial advice?
The source material highlights several areas. These often include discharging special responsibilities relating to specific regions, like development boards in certain states, the reservation of a bill for the consideration of the president, or, critically, matters related to the administration of scheduled areas. The governor may consult the Council of Ministers on these, but they ultimately act on their own judgment.
And here's the kicker. Article 163 specifies that if any question arises whether a matter falls under the governor's discretion or not, The decision of the governor shall be final.
That finality clause is immensely powerful. It essentially immunizes the governor's decision in that area from judicial review or constitutional challenge. It transforms the governor from a ceremonial head into a powerful political player during specific contingencies, making them the ultimate gatekeeper of executive legality at the state level.
So this discretionary power, especially in areas like reserving a bill for the president or appointing a chief minister when no party has a clear majority, it means the governor can, in those critical moments, override the political will of the cabinet. This is a point of intense scrutiny in political science and constitutional analysis.
Absolutely. The tension between the elected chief minister and the centrally appointed governor is constant. The governor's discretion acts as the safety valve, or, depending on your perspective, the pressure point, ensuring that the center's interests and the Constitution's integrity are protected.
Okay, now let's pivot to the engine room of the state executive, the chief minister. The CM.
Right. The chief minister, enshrined under Article 164, is the real executive authority, the de facto executive. They hold the position analogous to the prime minister at the center. The CM is appointed by the governor, and all other ministers are appointed by the governor only on the CM's advice. The CM is the linchpin, and the collective destiny of the ministry hinges entirely on their leadership and majority support in the assembly.
And the relationship between the CM and the governor is formalized by the duty of information under Article 167. This isn't just polite communication. It's a constitutional mandate that imposes accountability.
It is beautifully and intricately detailed. Article 167 lays down 3 specific duties for the CM, ensuring transparency and accountability to the nominal head. First, to communicate all decisions. The CM has to communicate to the governor all decisions of the Council of Ministers relating to state administration and legislative proposals. Second, to furnish information. The CM has to provide any information the governor asks for. And third, and this is the most significant, to submit for consideration. The governor can require the CM to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a single minister but which has not been considered by the Council.
Let's focus on that third point, as it's often overlooked but incredibly potent. Can you walk us through a scenario where the governor would actually invoke that power?
Of course. Imagine the Minister for Urban Development unilaterally decides on a major land deal or a significant policy change without consulting the rest of the cabinet. The governor hears about this decision through the bureaucracy or, the press. The governor, under Article 167C, can then write to the chief minister saying, CM, this decision taken by Minister X on Tuesday has not gone before the full cabinet. I require you to submit this matter for the consideration of the Council of Ministers.
So the governor isn't just a rubber stamp. They have the constitutional authority to compel a decision to be reviewed, debated, and potentially overturned by the entire cabinet if it was made unilaterally by one minister.
It acts as an essential safeguard against individual ministerial tyranny or overreach. It ensures that the principle of collective responsibility, that the entire Council of Ministers is responsible for every decision, is maintained in practice. The AG would be deeply involved here, advising the governor on the constitutional legitimacy of invoking this power and advising the CM on how to respond.
Speaking of collective responsibility, let's just reinforce that foundational principle governing the entire Council of Ministers.
The parliamentary nature of our state executive means the Council of Ministers is collectively responsible to the Legislative Assembly. That's under Article 164. And this means they truly swim or sink together. A decision by one minister is a decision by the cabinet. If the Assembly loses faith in the cabinet, it loses faith in all of them.
And the political implications during a crisis are immense, particularly regarding a no-confidence motion.
Indeed. When the Legislative Assembly passes a no-confidence motion, 2 things have to happen. First, all ministers must resign immediately, even if they happen to be members of the Legislative Council. Second, the cabinet can advise the governor to dissolve the Legislative Assembly and call for fresh elections, arguing they need a fresh mandate from the people.
But the governor has discretion here too, right? They don't have to follow that advice if the CM has clearly lost the House's confidence.
Precisely. If the ministry has demonstrably lost the confidence of the Assembly, the governor has the discretionary power to decline the advice to dissolve the Assembly. They might instead explore options for a stable alternative government. This is a crucial discretionary moment where the governor's political judgment, perhaps advised by the AG on legal implications, takes precedence.
Finally, let's circle back to the legislature, where the AG has special rights under Article 194. The structure of the state legislature itself is key to understanding the environment the AG advises in. we need to note the unique weakness of the bicameral state structure compared to the center.
Yes, the weakness of the Legislative Council, or Vidhan Parishad, is a central feature of state governance. While both the center and some states use bicameralism, the powers are drastically different. The key distinction is this. Unlike the central parliament, where the Lok Sabha and Rajya Sabha can resolve legislative deadlocks through a joint sitting mechanism, the Constitution does not provide for a joint sitting mechanism to resolve deadlocks between the Legislative Assembly and the Legislative Council in the states.
And what is the practical result of that missing provision?
It means the Legislative Council is effectively subordinate to the Assembly in almost all respects. The Assembly is always the dominant house. For ordinary bills, the Council can only delay the bill's passage for a limited period, a maximum of 3 months initially, and then 1 month in a subsequent passage. It can't permanently block it. The AG's advice becomes vital in this context, guiding the government on how to navigate potential delays and ensuring the legislative procedures used to overcome the Council's resistance are legally sound.
So the AG is the legal compass guiding the executive through a system where the Legislative Assembly's will is designed to prevail, ensuring that dominance is exercised within constitutional bounds. That is a heavy responsibility, especially given their lack of tenure.
It is the ultimate tightrope walk. They must support the government's policy goals while constantly ensuring the integrity of the Constitution, often under the shadow of potential dismissal if their legal advice proves inconvenient.
This deep dive has to expand the scope now, linking the state executive, which is advised by the AG, to the overarching constitutional principles that define India. Let's start with the big philosophical picture, our federal structure.
Right. If we connect this to the bigger picture, we see the state administration operating within a framework defined by Article 1. India, that is Bharat, shall be a union of states. This phrase is loaded with constitutional intent, implying two non-negotiable points. First, the Indian Federation is not the result of an agreement among the states, meaning the states didn't come together voluntarily to create the union. And second, no state has the right to secede from the Federation.
That leads to the famous description of our structure. We are not an indestructible union of indestructible states like the U.S. is.
Precisely. We are an indestructible union of destructible states. Parliament has the power to unilaterally change the area, boundaries, or name of any existing state by a simple majority vote, which is a significant indicator of the unitary strain in our federal structure.
So what are the other unitary features, as highlighted in the sources, that allow the center to exert control over the state executive apparatus that the AG advises? We need to list them, but also analyze the strategic reason for each.
The strategic design includes several levers of central control. 1. A strong center. The union list contains more important subjects than the state list, ensuring central legislative dominance in critical areas like defense, foreign policy, and railways. 2. Single constitution and single citizenship. This fosters unity and uniformity across the entire political landscape. 3. Integrated judiciary. Courts enforce both central and state laws, linking the judicial structure firmly to the center. Then there are the All India Services, AIS. Services like the IAS, IPS, and IFOS are recruited and trained by the center, but they occupy key posts under the state governments. While immediate control rests with the state, the ultimate disciplinary control lies with the central government, and of course, emergency provisions. Under Articles 352, 356, and 360, the system can transform from federal to unitary during a crisis without a formal amendment.
And the most direct, practical manifestation of central control over the state executive system we just discussed comes via the governor, using those emergency provisions, correct?
Absolutely. The power to recommend presidents rule state emergency under Article 356 for a breakdown of constitutional machinery or Article 365 for failure to comply with union directions, that power is explicitly held by the governor. This is the moment when the unitary structure fully asserts itself. During president's rule, the governor functions as a full agent of the president, essentially taking over the executive functions of the state government.
Okay, now let's shift to the legal philosophy that governs both state and central laws. Constitutional supremacy, which is enforced by the judiciary.
In India, the Constitution is the supreme law of the land, and every statute law must conform to its requirements. The judiciary, specifically the Supreme Court and the High Courts, holds the power of judicial review, the power to check constitutionality. This power is explicitly granted in Article 13 concerning fundamental rights, assigning the judiciary the role of the sentinel on the qui-vive, the watchful guard of the Constitution.
This leads us naturally to the two critical constitutional doctrines that the judiciary uses to operationalize judicial review and resolve federal conflicts: Let's dedicate some time to the doctrine of separability or severability.
This doctrine comes directly from Article 13.2, which prohibits the state from making a law that abridges fundamental rights and dictates that any law made in contravention of this clause shall be void to the extent of the contravention. The doctrine of separability is the mechanism for applying this rule pragmatically. It states that if a law violates fundamental rights, only the offending portion is struck down, provided the valid part can be logically separated from the invalid part.
Why is this doctrine necessary? I mean, why can't the entire law just be scrapped?
It is judicial pragmatism.
Sure.
Scrapping an entire complex piece of legislation because one minor section violates a right would create legislative chaos. So the judiciary uses this doctrine, it's often called judicial surgery, to save the constitutional integrity of the law. If the valid part can stand alone without the offending part, the rest of the law survives.
And the classic illustration cited in the sources for this is the A.K. Gopalan versus State of Madras case from 1950. Can we elaborate on what happened there?
In that pivotal early case, the Supreme Court was examining the validity of the Preventive Detention Act of 1950. The court found that Section 14 of the Act, which stated that a person could not disclose grounds for detention in court, violated the fundamental rights guaranteed under Article 22. So, applying the doctrine of severability, the court struck down only Section 14. The rest of the Preventive Detention Act, which was constitutionally sound, remained valid and effective. It's a clean example of how the judiciary prevents legislative overreach without crippling the government's necessary functions.
That makes perfect sense. Now let's tackle the second vital doctrine, which is crucial for resolving conflicts in a federal system, the doctrine of pith and substance.
Right. The doctrine of pith and substance is essential when legislative powers appear to overlap between the union list, state list, and concurrent list. It's used to determine which legislature, state, or union has the authority to enact a specific law. Pith means the true nature, and substance means the essential character.
So how does the judiciary determine this true nature?
It examines the challenged law as a whole to ascertain its core essence. The principle dictates that even if a law incidentally trenches upon or touches upon a subject in another list, if its substance belongs to the list under which the enacting legislature operated, the law is upheld. It prevents the legislative efforts of the states or the union from being crippled just because they might brush against the domain of the other.
Let's use a practical conflict scenario to illustrate this. Imagine a state government passes a law aimed at regulating markets, which is a state subject. But the regulation also incidentally impacts the operations of a central public sector industry, which falls under the union list.
Exactly. The central industry might challenge the state law, arguing it encroaches upon the union's legislative domain. The court will apply pith and substance. The question is, what is the primary object of the state law? If the court finds the law's pith and substance is genuinely about regulating markets and ensuring fair trade practices, a core state function, then the law will be upheld, even if it incidentally affects the central industry. But if the state law's primary intent was, in substance, to regulate the internal management of the central industry, it would be struck down as ultra vires, beyond its powers.
This sounds like a necessary, pragmatic, judicial tool to prevent federal gridlock, acknowledging that absolute clear-cut demarcation is impossible in a complex modern economy.
It is the judicial recognition of legislative imperfection. The sources note, for instance, that the validity of the Industrial Disputes Act passed by Parliament was upheld even though it applied to municipalities, which is a state subject, because its true pith and substance related to industrial disputes.
Okay, now let's bridge these constitutional structures to the core socioeconomic and internal security themes that feature heavily in Maine's examination analysis. Let's look at land reforms and their linkage to poverty elimination.
This relationship is fundamental to understanding the realization of the welfare state ideals enshrined in the Directive Principles of State Policy, or DPSP. The DPSP, though non-justiciable, mandates that the state apply these principles in making laws, as stated in Article 37, and land reforms are the most potent example of realizing the DPSP aim of reducing inequality.
What implementation measures, often advised upon by the Advocate General's office, were undertaken by states to realize this?
The measures were sweeping. They include the abolition of intermediaries like zamindars and jagirdars, who are the primary source of feudal exploitation, enacting tenancy reforms to secure tenure for actual cultivators, imposing ceilings on land holdings, distributing surplus land to the landless poor, and promoting cooperative farming. These actions directly address socioeconomic justice, reduce rural poverty, and fulfill the aspirational goals of the Constitution. And the AG's office would be critical in drafting and defending the constitutional validity of these complex land reform acts.
So the AG is directly linked to the success or failure of the state's most profound social engineering efforts.
Absolutely. The legal defense of these land reform acts in the high courts often rests heavily on the expertise and arguments put forth by the AG's office.
Finally, let's look at internal security, specifically the challenge of left-wing extremism, LWE, and how constitutional provisions, or their failure, play a role.
LWE is frequently linked to questions surrounding the administration of tribal areas and the non-implementation of constitutional provisions, specifically under Article 244, which governs scheduled areas and tribal areas. The core issue often boils down to the impact of the non-implementation of the provisions of the Fifth Schedule.
And how does the Fifth Schedule differ from the Sixth Schedule? Why is that distinction key to understanding the challenges facing tribal areas?
This is a vital distinction. The Fifth Schedule covers the administration and control of scheduled areas and scheduled tribes in most tribal regions across India states other than Assam, Meghalaya, Tripura, and Mizoram. It establishes tribal advisory councils and gives the governor specific powers over land transfer and money lending to protect tribal interests. The failure to effectively implement these protective provisions is what directly contributes to the growth of left-wing extremism. Alienation provides fertile ground for radical ideology.
And the Sixth Schedule is focused differently.
Yes. The Sixth Schedule is highly specific, applying only to those four northeastern states: Assam, Meghalaya, Tripura, and Mizoram. Its rationale is to provide a much greater degree of tribal self-rule through autonomous district councils and regional councils. This design ensures greater protection for cultural identity. The fact that the Fifth Schedule areas typically suffer more internal security issues than the Sixth Schedule areas speaks volumes about the level of protection afforded by the two structures.
So the AG's office would be central to advising the state government on how to harmonize the general laws of the state with the specific legal protections mandated under the Fifth Schedule.
Exactly. When the state executive, advised by the AG, fails to create appropriate legal safeguards to protect tribal lands or mismanages resources, it creates a vacuum that LWE exploits. It's a direct link between constitutional implementation and internal security. The whole system has to work in concert.
And that filter, the AG, is ultimately subject to the political winds of the ruling party.
That is the enduring reality of the office. The fact that the AG holds office at the pleasure of the governor, meaning the ruling government, is the constitutional design choice that makes the office susceptible to political pressure, even though its function demands the strictest adherence to the rule of law. Hashtag outro.
So, to briefly summarize our core takeaways from this substantial deep dive, the Advocate General of State is not merely a government lawyer, but the indispensable constitutional link, mandated by Article 165 and possessing unique legislative privileges under Article 194. This office operates within a complex quasi-federal structure defined by the formal checks of the governor, especially the critical discretionary powers under Article 163 and the power to police the cabinet via Article 167 and the collective responsibility of the chief minister's cabinet.
And we've seen how the seemingly administrative chapter in Polity provides the legal scaffolding for the state's most challenging policy areas, from defending land reform acts that pursue social justice to advising on legal adherence to the Fifth Schedule to mitigate internal security threats. Understanding the AG's lack of tenure is central to understanding the functional limitations of legal independence in our parliamentary system.
This leaves us with a final provocative thought for you to consider as you continue your journey of learning. We discussed how the state's legislative council, where it exists, is structurally subordinate to the Assembly, giving the executive dominance in lawmaking. Now, consider the flip side. If the Advocate General, as the chief legal advisor, plays such a crucial, solitary role in advising the state on its constitutional duties, especially when those duties involve defending the state's autonomy against central overreach or challenging powerful corporate interests in court, how does the lack of security of tenure for this specific constitutional post influence the government's courage to take on politically difficult legal battles? Is the AG the guardian of the Constitution or merely the legal voice of the day's politics?
It's a key tension in India's legal administration worth exploring further, the constitutional post that must maintain independence while serving at political pleasure.
A huge, sincere thank you once again to all our existing members for their continuous support. It truly allows us to keep bringing you this super useful, in-depth content. And for our new listeners, we humbly remind you, If this deep dive was helpful, please subscribe to the YouTube channel and join the paid membership community, if capable, to support our work.
Please remember to like this audio and drop your comments below. Your engagement helps us immensely and guides our future deep dives.
And as a final reminder, free notes with practice PYQs are waiting for you on our Telegram channel, and premium notes with extra resources, including model mains answers, are available in the Discord channel for Legend YouTube members. Do join there to ensure you have all the tools for success. We'll be back soon for the next deep dive. Until then, keep questioning the constitutional framework.